indulgence, praying for your lordship's kind leave for filing memorandum of appeal without the certified copy.
Yes,
I'm
leave
grateful.
granted.
My lord, similar prayer, my lord. Similar prayer.
Lord, may I have my lord's leave, my lord? This is a matter which was appearing in my lord's list as item 57. Last week, my lord, we got an interim order from the other bench which was having my lord's determination. For 7 days, the receiver was restrained, my lord, not to go and collect the money.
When is it
My lord,
expiring?
it is not appearing in the list. I believe it is expiring tomorrow, my lord. The 7 days protection is expiring.
So Friday we will list it.
Very well, my lord.
But you are mentioning upon notice.
Upon notice, upon notice.
For the other side, my
Friday you list it under the caption for extension of interim order.
my lord,
My
maybe
It's an appellate side matter or
Appellate side matter, my lord. Appellate side matter.
yes.
my lord, maybe point to mention my lord, original side matter, my lord.
Ah.
My lord, the petitioner, my lord, the applicant, 41 candidates were selected for the post of 41 vacancy for granting license of MR dealership in Darjeeling district. Out of that, 38 candidates were granted license. 3 candidates were not given license. They filed a writ petition, and at the time of hearing, the state respondent filed a report stating that the applicants have given no objection in favor of other 3 candidates. That is how they had not been given license, my lord. But no objection was given.
And what happened to your writ petition?
Writ petition that His Lordship Honorable Justice Vivek Chaudhary directed the respondent authority to consider the candidates of the other candidates along with the applicants, my lord.
Against which you are on appeal.
Yes, my lord.
It's a fresh matter or it was?
Yes, matter, my lord.
Yes, please. Yes.
Lordship, may I permit to mention the 2 item number 140 and 141,
Appellate side.
appellate side.
Ah.
My lord, I am praying for upgradation, my lord.
What is the urgency?
My lord, urgency matter is relating to the tender process of supply of cooked diet at Mental Hospital, Purulia. Without implemented, the applicants as a responded in the writ petition, stay order has been passed and CMOH cancelled the work order of the applicant. Applicant has filed application for addition of party and vacating application of your lordship order.
माय लॉर्ड, मैं हूं प्रताप बसु, पिटिशनर। मैंने हिंदी में बात करना चाहती हूँ। तो एक तो PIL किए थे मैंने 2023 में, PIL नंबर WPA 89 और 2023। तो आपका इससे पहले भी एक तो PIL किए थे।
You give the letter.
सर thank you,
Your
sir.
Lordship, in
Urgency,
this
sir.
matter, I was appearing from for the Gram Pradhan, but now it was pre-election, but after election, someone else is the candidate, so I don't have the power. So
let the matter come.
yesterday, actually, he served me the mentioning.
You serve notice on the Pradhan of the Panchayat.
Grateful, Your Lordship.
You tell him.
My lord, with the leave of Honorable Justice Bhattacharya, my lord, I am mentioning before my lord Chief Justice, my lord. This matter was heard by your lordship and also Justice Vivash Patnaik. That is
Contempt
the
petition.
contempt petition. My lord, SLP has been dismissed. My lord, kindly consider they are suffering since 2011. Before
Next week we will list it. You find out convenience of this Patnaik.
I'm grateful, my lord, I'm grateful.
We'll first pronounce the judgment on the appellate side, and then we'll.
Appellate side item number 124 for judgment.
But I'm appearing in one of them.
For all the reasons the aforesaid, the impugned judgment and order calls for interference. Accordingly, the judgment and order is set aside and quashed. Consequently, the panel prepared afresh on 24th of February 2022 for recommendation to the post of constables in West Bengal Police pursuant to the impugned judgment and order of the tribunal also stands set aside and quashed. The panel of the recommended candidates published on 26th of March 2021 for the post of constables in West Bengal Police 2019 stands restored. Accordingly, the following directions are passed by this court. Posts against which the candidates whose names were not in the original merit list dated 26th of March 2021 were appointed shall be treated to the effect upon passing of this judgment to be filled up by reserved category candidates whose names were left out in the revised merit list dated 24th of February 2022. The reserved category candidates whose names featured in the original merit list dated 26th of March 2021 and who were excluded in the revised merit list published on 24th of February 2022 shall be given appointment after completion of all formalities in this regard against the vacancies that were sought to be filled up by the present recruitment notification. Notional date of appointment of such reserved category candidates shall be the date when other candidates in the original merit list were appointed, strictly maintaining their seniority as per the said date. Pay scales of the commissioners as well as other benefits of such pay scales as well as other benefits of such candidates are to be fixed on the basis of the notional date of appointment. It is however made clear that such reserved category candidates shall not be entitled to salaries and other financial benefits from the notional date of appointment with the actual date of joining. Concerned authorities are directed to complete the aforesaid exercise within a period of 4 weeks from the date of receipt of the server copy of this order. The appointment of the candidates whose names did not feature in the original list dated 26th of March 2021, but was included in the revised merit list dated 24th of February 2022, shall stand cancelled with effect from the date of passing of this judgment. However, having regard to the observations made in the preceding paragraphs, the concerned authorities are directed to consider such candidates for absorption and/or regularization, as the case may be, against vacancies any available. WPST number 30 of 2022 and WPST number 31 of 2022 stands above. WPST number 9 of 2022 and WPST number 12 of 2022 are disposed of in the aforesaid directions. All pending connected applications are disposed of at no cost.
Deeply obliged. Deeply.
Yes.
Original side daily list item number 1.
But I am appealing for the respondent.
My lord, there is a delay of 117 days. There was a direction to file opposition by the respondents.
I'm out of time to file my opposition.
Why, we'll condone the delay. You argue that.
I leave it to the discretion of the Lord.
You have heard Mr. Amit Shah, Leonard, Amit Sharma, Leonard, advocate, senior panel counsel for the appellant, and Mr. So-and-so, Leonard, advocate for the respondent assessee. There is a delay of 117 days in filing the appeal. Though the learned advocate for the respondent assessee would vehemently oppose the delay, on perusal of the averment set out in the application, we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, the delay is condoned. Let the appeal be listed for admission, so and so.
Grateful, my lord.
Item number 2. There is a delay of 657 days, my lord. But the envelope has returned back with the endorsement moved, my lord.
So, fresh notice to the respondents to the correct address, returnable in 2 weeks. Affidavit of service be filed. Next.
Item number 3. There is also a delay of 126 days, my lord.
Respondent served?
Yes, they have received it, my lord. May I file the affidavit service?
We'll condone the delay.
Yes, my lord. And it shows item delivered, my lord.
And you please inform Mr. Subhash Agarwal. He appeared for the.
Yes, ma'am.
You have heard the learned senior panel counsel for the appellant. No, full stop. Notice on the respondent has been served. There is a delay of 126 days in filing the appeal. We are satisfied with the reasons given by the appellant for not preferring the appeal within the period of limitation. Accordingly, application is allowed. The delay in filing the appeal is condoned. The learned advocate for the appellant is directed to serve notice on Mr. Subhash Agarwal, learned advocate, who appeared for the respondent assessee before the learned tribunal. Let the matter appear for admission on so and so date.
For
Next.
admission tax matters, item number 4.
Please, my lords, I'm appearing for the appellant in the matter. My lord, if your lordships are pleased to take up the memorandum of appeal, may I first encapsulate the brief facts? Here, my lord, the appellant before your lordships.
It's a
Is it-
penalty.
My lord,
It's a penalty matter.
sorry, my lord.
271 1C.
271 1C, my lord, it is 205 matter. It's a penalty matter, but my lord, it's essentially an order where, my lord, there are 3 counts where we are challenging the order.
Where are the
The-
questions you have?
My lord, the questions are, my lord, in the memorandum of appeal.
Respondent has been served? No. It's coming
My
up
lord, it was supposed to come up on the 4th, my lord. It has come up
earlier.
earlier, my lord. But my lord, I am ready to argue. I will only indicate this.
But probably
We will serve and come back if that falls from your lordship. Will do that, my lord. Because it's a 205. The case is this, my lord. The appellant before your lordship is, my lord, the managing director of a company. He had followed the provisions of 128 of the Companies Act, where he is bound to, my lord, follow the double entry system. He has deducted TDS, my lord, TDS not deposited with the government. Now the difficulty is, my lord, the revenue authorities are chasing him, my lord, without, my lord, the acceding to the bar of 205, where, my lord, he is not the person whom they can, because the liability is with the entity deducting the tax. The entity deducting the tax is the company. Incidentally, he was the managing director of the company, and that is the reason, my lord, the ITAT has held with an artificial distinction that since he's a managing director, 205 will not apply, and he and the company are the same entity. That's my case before your lordship. That cannot be
it will
done.
come up on 4th.
Indeed, my
By
lord.
the time you can find out who's going to appear. You have served the copy of the stay petition also.
My lord, I'll just check. I should not make a submission without seeing. It is submitted.
The principal commissioner.
Lord, we have served on the deputy commissioner and, my lord, the assistant director of income
No,
tax.
you need to serve
We
on
have
the
to, my lord.
commissioner of income tax.
We'll serve it and we'll come back.
Judicial.
We'll do that.
Let notice be served on the commissioner of income tax within bracket judicial, along with the one set of papers in this appeal. Let the appeal appear for admission on 4th.
I'm very deeply obliged. That's deeply obliged.
Item number 5.
My lord, I'm appearing for the appellant, my lord. Though I have served the respondent, my lord, I don't think anybody is appearing, my lord.
What is the matter?
My lord, is delayed contribution of employees contribution to provident fund, my lord.
Is it not covered by?
My lord, that is what I need to explain to your lordship, my lord. This matter, my lord, ultimately traveled to the Supreme Court after litigation being fought in various honorable high courts, and Supreme Court has delivered the judgment in checkmate. Now, my lord, your lordship is also aware, my lord, that Finance Act has carried out the amendment. So far as earlier there was no distinction between employees contribution to provident fund and employees contribution. Now, my lord, by Finance Act of 2021, explanation has been inserted in section 43B, and now also simultaneous amendment has been carried out in section 36(1)(6). Now, my lord, our case is before twofold, my lord. One, I would be very humbly canvassing a new case, my lord, which although was taken up till the stage of learned CIT appeal, my lord, but unfortunately for some reason that point was not canvassed before the tribunal. But a pure question of law, I will, my lord, when I argue with this matter, if your lordship kindly permits me, takes up the matter next week, my lord, that tribunal is supposed to decide the law as it prevails, my lord, and Finance Act is only made prospective.
In the ground memorandum of appeal,
my lord,
before the tribunal,
my lord,
did you raise this issue?
No. But I if your lordship kindly pardon me, I'll only pray, my lord.
Before the commissioner, you had raised.
Yes.
Let us see the grounds raised before the learned commissioner.
my lord, in the written submission before the learned CIT appeal, this ground was specifically taken, my lord.
Now, what is the order at page 129? That is Tripti Enterprises.
This is, my lord, this argument,
Hmm.
I had made an alternative submission before the learned tribunal. This is a judgment of the Cuttack bench of the learned tribunal,
Hmm.
that even if the employee's contribution is disallowed, the payment being delayed, an alternative plea can be taken before the assessing officer that it can be allowed as a revenue expenditure under section 37.
That plea also the tribunal has not gone.
No, my lord. I had placed this decision before the tribunal. I had also filed a written submission before the tribunal. But, my lord, tribunal only going to the judgment of the Honorable Supreme Court in checkmate. And incidentally, I would also place the judgment of the Supreme Court, my lord, next week, if your lordship takes up.
Yes,
Your
sir.
lordship will very kindly find only there's a reference to the amendment in Finance Act of 2021. The Honorable Supreme Court did not deal with it. And as the law stands, my lord, the Finance Act of 2021 is only prospective. It has not been made retrospective. And your lordship is very well aware, my lord, if any liability is imposed by an amendment, even in the absence of the law, there being any indication, whether it is retrospective or prospective, it will always apply prospectively and not retrospectively.
Whether the Commission of Appeals decided this effect
No,
of the
no,
Finance Act 2021.
no. The Commissioner Appeal and the tribunal both went by the judgment of the Honorable Supreme Court in checkmate. Without paying any attention, I'm deeply grateful to your lordship, my
But
lord.
you could have raised this as a ground before the tribunal.
Unfortunately. But, my lord, till the
But you
Commissioner,
serve notice on the respondent.
my lord, I've served the notice on the respondent, my lord, concerned respondent. But I am told, my lord, I am supposed to serve the Principal Commissioner of Income, the concerned Principal Commissioner of Income Tax.
Commission of Income Tax, Judicial.
No, not judicial. No. Concerned Principal Commissioner regarding this IT 260 appeal, not judicial, before the Commissioner. In case of REIT and
Yesterday, somebody said it was CIT Judicial.
no. Regarding this, my lord, CIT judicial will not accept the my lord.
No, previous matter we have dictated, you should have told us. No?
I was
Sir, previous matter, we said serve notice on the
concerned CIT.
Commission of Income Tax Judicial. Instead of that, you say concerned Principal Commission of Income Tax.
Sorry.
Same order in this. List the appeal for admission on 11th October.
I'm grateful.
Item number 6.
He should forward it. That's correct. What Lordship says,
Yes.
that once it is served on the concerned officer, he can place it before the concerned Principal Commissioner, get the allotment.
Yes. That is my lord.
Why they should be driven from
I
here and
understand.
there?
I understand.
No, you speak to them.
My lord, I'll do.
I'm grateful, my lord.
New application, item number 6.
Not the affidavit and service we kept on record. I have filed.
Yes. Affidavit of service kept on record.
Lord, this is my application. Lord, the applicant, my lord, the regular supplier of a Manila goods, which to the railway authorities, my lord, the regularly, my lord, the supplied for a limited period of 6 months validity on the basis.
Respondent served.
My lord, the response service upon the learned advocate who appeared in the learned code below. My lord, the not all the respondents, but all the respondents he appeared.
And who appeared?
Mr. D.N. Dye.
Where is the order passed by the learned single bench?
This is in the memo of appeal, my lord.
There is a delay of 5 days.
This is a the learned trial judge wrongly held that in terms of the general terms and conditions, 30 months has not been covered during this period. The inspection.
But why did you file a writ petition? You could have filed up an application for arbitration.
No.
Because under the general conditions, obviously, show us the conditions of contract.
My lord, this is not the arbitration conditions. In there, my lord, the only things for a moment.
No, how a writ is maintainable?
Oh, yes, my lord, page 71, my lord, for a moment. Page 71, the penalty has been notice has been of the GA, my lord, 71 of GA.
No, where is the contract? Or work order issue? Where are the general conditions of contract?
That general condition, my lord, which has been supplied by the learned friend in learned trial court below. No, the one copy supplied by the learned friend of the learned court below, before the learned court below. Now there, I think, my lord, there is any type a contract, my lord, the arbitration clause is there. But here is the case, my lord, when the trial court is considered, the panel provision has been kindly appreciated, page 71 of the GA. Penalty GA 71. After 2 years, after the completion of the contract, after 2 years, they have got the inspection in absence of the petitioner. That
is a question of fact. How to agitate that?
No, this is not the question. This is the memo has been issued by the railway authority. Kindly appreciate page 71 my GA application, which has been challenged before the trial court below. Page annexure P17 of the writ petition. So at the moment there is no, my lord, I think, my lord, there is no question of arbitration, as because the terms and conditions are already ended after the 6 months. And thereafter the panel provision has been done. Notice has been done.
Clause number 2900.
I do appreciate.
In the event of any question, dispute or different arising under these conditions or special conditions or in connection with this contract, except accepted matters, the same shall be referred to the sole arbitration of the arbitrator in terms of the arbitration conciliation.
I do appreciate.
Should not have filed a writ petition.
Things for a moment. My contract was only for 6 months. After this validity period 6 months, there is no
dispute. Definitely dispute arises out of that contract. So if you, according to you, this claim is time bar, that is a factual issue to be agitated. You took a risk of filing a writ petition and now you have invited.
My lord, I draw losses can only one attention, my lord. Kindly appreciate. My lord, the page 71 of the G application, this is the annexure P17 of the read application. That is the panel provision has been done, no memo has been issued. That's why, my lord, come before this read application, read jurisdiction. That is after 2 years. There is some disputed facts regarding, my lord, the validity period of 6 months.
But the learned judge records that the sample test can be taken. No, although the sample tests in the present case were taken beyond 6 months, such tests took place well within the warranty period of 30 days.
That is warranty period on the basis of the general terms and conditions. My explicit submission, general terms.
General GCC.
No, my lord, this is not the case, my lord. My appreciate, my lord, the tender form. The tender form, it is said, my lord, and the, my lord, the purchase order. I do appreciate, my lord, the page 36, my G application. Page 36 of G application.
Yes.
P1. I drawing losses attention. The serial number description, bottom portion, my lord, serial number 1. Consignee firm should submit TC and GC. TC and this is general certificate, my lord, the validity certificate by the manufacturing company, inspection of the supply. Second, all other terms, this respect all other terms and conditions as per terms and general tender condition. My lord, my responsible submission so far the guarantee certificate issued by the manufacturer company, that is not within the ambit of the general terms and conditions. Save and accept other terms and conditions provided general conditions.
You please see same page, serial number 2, first column.
Yes, all other terms, all other terms.
The contract shall be governed by the latest version along with all correction slips of the general conditions of contract.
Yes, I do.
And all other terms and conditions incorporated in the tender.
That's true. My responsible submission here, in the clause 1. My clause 1, my lord, this is the certificate, guarantee certificate issued by the manufacturing company. I cannot improve.
No, you are the supplier. You have
I am
given the
supplier. I am manufacturer company. This is the instruction. My lord, the manufacturer company. Then a lordship kindly appreciate. I am drawing lordship's attention. Purchase notice memo. This is a very vital thing. My lord, the page 44. Page 44. Page 44.
Yeah.
Annex F.
Page 44.
Yes.
Yes.
My lord, I drawing lordship's attention. My lord, the serial number 7 and 8. Statutory violation clause application within the validity of the process. My lord, second 8. Brand trigger 1 from submit manufacturer test cum guarantee certificate. Manufacturer guarantee certificate. The supplier cannot issue the certificate of the guarantee certificate. This has been issued by the manufacturer company. This is dispute arises. My responsible submission. The manufacturer company has issued the certificate for considering the nature of the products only for 6 months.
Which is the order which was challenged in the writ petition?
That is, my lord, page 71. Page 17 of this. Page 71. This is the panel provision has been done after 2 years. After completion of all the terms and conditions and all the things completed, the inspection done after 2 years, and in absence of my absence. Apart from that, I only one time lost his attention.
When did that 6 months period expire?
That is, my lord, seems, my lord, the 4/9/2019. Thereafter 6 months. My lord, I drawing losses attention. Only one indulgence, my lord, page 50. Page 50 of this memo, of this year. The bottom portion. When the goods supplied, the authority received and thereafter tested.
Actual date of supply is 4/9/2019.
4/9/2019.
So
then 6 months validity, and that at the time of supply, on the date of supply, they have received after testing. For a moment, the bottom portion. This is the notice issued by the authority.
Suitable.
Yes.
Found suitable. But
the test was conducted on the same date. How the after 2 years?
You have to serve notice. There is a delay of 5 days in filing the appeal.
Yes, that I have explained, my lord.
No, that we can condone.
Yes.
But the respondent should appear in their presence.
I have the notice, my lord, the learned advocate who have already appeared in the learned court below. Of your lords is desired to pass it. Order, my lord, so serve again, my lord.
All right. The learned advocate appearing for the appellant shall serve notice on Mr. D.N. Ray, learned advocate, D.N. Day,
Mr. Mike.
Who's the panel lawyer?
The panel lawyer of India government.
Mr. D.N. Ray / Mr. Saurav Halda / Mr. Rajesh Kumar Shah, learned advocates who had appeared for the respondents in the writ petition. Let the matter be listed for admission on 4th October. 4th October.
Yes.
We will return this. You make one more copy.
Yes.
So that Usually to boli sama. No. No, we will edit it. But in their absence. Oh, new application.
Item number 7 and 8.
In respect of 8, I am the appellant. In respect of
7, I am there.
is the appellant. By the impugned order,
These are all hearing matters, is it?
this is hearing matter, my lord.
But it's a stay application really, not
The application is there, my lord.
But the appeal has to be heard.
Appeal has to be heard, my lord. There are certain points which required to be adjudicated, my lord.
We can have it after vacation.
I was only praying for this. Not the court has directed certain amount to be paid to us along with interest up to a particular date, and in default on payment of the amount within that date, a further interest would be carried forward. Let them deposit the amount with the registry of this honorable court, and it should see around
Appellant is
that.
the National Insurance Company Limited.
That doesn't make them a favor.
2022 appeal.
My lord.
So
But
they
it's
have
a
been-
claim of 2004.
They cannot be prejudiced, my lord, if the matter
Claim of
can be heard out.
2004, which ultimately fructified in my favor in 2022.
All right. Since the appeals have to be heard finally, some of for want of time, the same cannot be taken up today. Let the appeals be listed for hearing. Under the caption for hearing. You give a date, Anjan. After vacation, we will give it. Next,
Item number 9.
This is my application. This is an intra-court mandamus appeal, my lord. Challenging an order made under section 148A(d) of the Act. And the facts of this case are peculiar, my lord.
what is the ground on which it was challenged?
My lord, I tell your lordship, 3 148A(b) notices were issued in this case. My lord, kindly take one by one. It will not take much. My lord, kindly take, my lord, page 68. This is the first 148A(b) notice. The allegation was restricted to sale of 9 immovable properties amounting to rupees in excess of rupees 4 crores. Then, my lord, I immediately replied, the assessee immediately replied, and the reply your lordship will find at page 71, where the assessee categorically denied all the allegations and made it abundantly clear that these properties do not belong to the assessee at all. Your lordship will find the reply at page 73.
The gist is given here.
Gist is there at 71, then 73 is the reply.
I do not have any more property as mentioned.
Nothing, my lord, nothing. Then, my lord, comes the second show cause notice. That is at page 10, starts at page 106. Again, identical allegations being made. Your lordship will find the allegations at page 107 being annexure to the 148A(b) notice.
Is verbatim the same?
Yes, my lord, kindly come to page 109 for the lordship's kind consideration. This notice was issued without verification at all. It was under verification. Your lordship will find the verification status under verification. My lord has got that. So, my lord, the petitioner, the appellant, immediately replied to the said notice. Your reply, your lordship will find at page 120.
Yes.
My lord, now again, the petitioner points out that the verification status is shown as under verification. Your lordship will find that fourth paragraph at page 120.
Therefore,
the reply was so
may be carried out. opportunity of being heard be
Right, right.
given to the tax.
Then, my lord, comes the third notice. At page 124, an additional reason was cited, that is, allegedly, the appellant received cash loan in excess of rupees 62 crores.
But they have given up this property issue.
Not, my lord, this property issue, they did not give up. This is an additional.
Additional.
So, my lord, additionally, your lordship will find now that they now say that the petitioner had received cash loan in excess of 62 crores.
Yes.
My lord has got that. That is paragraph 2.
Yes.
Now, my lord, kindly now take the annexure to the said show cause notice, which starts at page 129, and kindly turn over to page 133.
Yes.
Yes, your lordship will find, though it is alleged in the show cause notice that the petitioner obtained cash loan of rupees 62 crores, in excess of 62 crores, the computation table at page 133 shows it is only 1.50 crores. This is their own document. But the petitioner thereafter submits his reply and takes all the available points. And now, Miller, kindly take the approval 148 AD order. Your lordship will find at page 148 AD order. Your lordship will find in the second volume, I believe.
Page 153.
Page 153. 153 it starts. Now, Miller, kindly take, this is unbelievable in the sense, kindly take page 164. The quantum of income is limited, which has escaped assessment, is limited to 4 crores 2 lakhs, which is the property issue. No approval was obtained at all
for the
cash loan. And kindly, my lord, take page 154 for once.
This objection was raised in your reply. No,
My lord,
you are not aware of it.
This is not. But a complete non-applicable. There are 3-4 very important issues. Whether multiple notices can be issued under section 148AB pertaining to one assessment year, relevant assessment year. Second, my lord, even if it is so, whether, my lord, if the reasons for reopening as contained in the 148AB notice is at variance with the information, whether at all that notice is sustainable or not. Third, my lord, whether, my lord, if an approval has been obtained which is restricted to one transaction, whether an order under section 148D can be sustained when it covers multiple transactions. This is a completely botched up case. And the records will speak for itself. Your lordship will find 154. Very interestingly, they have treated us that we are operating a star rated hotel. The assessee is not into the business of hotel at all.
But while he issued the second notice,
right,
did he consider your reply to the first notice at page 73?
Nothing. Lordship will find it from the records itself. There were 2 notices pertaining to the property. We replied to the 2 notices. Your lordship has seen at the second notice. Second notice that, my lord, we also pointed out that issue is pending under verification. without completing the process of verification, how can a notice under section 148A(b) could at all be issued? And then comes this, my lord, this additional flavor of cash loan.
Instead of dismissing it.
And the approval speaks for itself. Time and again we have pointed out
Sharma, you file your affidavit, it's better.
My lord, this is similar to that. This is same assessees. Another case was appeal was dismissed by
the facts and circumstances. But is it the, I
This is
put
the case of that Rukka.
yes, the Rukka is there.
No, this issue is multiple notices. If suppose, are we to presume that the first notice at page 68 was given a go by when you issued the second notice under page 106? And if the third notice contained an additional ground, then are we to ignore the second notice? Then the third issue they have raised is
approval
with regard to the second issue.
In the third notice, my lord, 148B, both the allegations were there.
But then at least he should say what was the need for issuing the second notice.
My lord, initially in the first notice, no document was supplied. What I have gathered from this brief, my lord.
But if I have not, if the petitioner does not own the property, what documents the petitioner would supply?
I'm not submitting that petitioner did not supply. The assessing officer did
No,
not supply.
but in the second notice,
In the second notice, the documents were supplied to the.
But additionally, may I point out?
Portal says the verification status is under verification.
Well, very interestingly, one additional document. This is from government records. Kindly take page 170.
We will restore the writ petition. You file your affidavit in the writ petition.
My lord, all these were what has been contended before my lord, all the disputed question of.
Even the approval is disputed question of.
Is touching upon the jurisdiction. Please come. This intra-court appeal by the writ petitioner is directed against the order dated 5th June 2023 in WPO 930 of 2023. In the said writ petition, the appellant had challenged an order passed under section 148 capital A within bracket small d of the Income Tax Act 1961 within bracket A dated 30th March 2023 for the assessment year 2019-20. The order, the said order was questioned on the ground of violation of on the ground of lack of jurisdiction, violation of principles of natural justice, failure to obtain approval under section 151 of the Act on one of the issues on which the assessment was sought to be reopened. However, the learned single bench by the impugned order had dismissed the writ petition, stating that the appellant can raise all points before the assessing officer in the course of the proceedings subsequent to the notice under section 148 of the Act. After elaborately hearing the learned senior advocate appearing for the appellant and the learned standing counsel appearing for the respondent department, we are of the view that since jurisdictional issue has been raised by the petitioner, by the appellant in the writ petition, an affidavit should have been called for from the respondent to adjudicate the jurisdictional issue. The legal issue canvassed in this appeal as well as in the writ petition is that is whether the assessing officer is empowered to issue multiple notices under section 148 capital A within bracket small b of the Act for in respect of the same based on the same reasons when admittedly the assessee has submitted the reply to all the three notices. Further, it is contended that when the second notice was issued, second notice dated 10th March 2023 was issued, the verification status as could be seen from the inside portal, shows the matter to be under verification within inverted comma. This aspect was pointed out by the assessee in the reply dated 16/3/2023, contending that after due verification, an opportunity of being heard may be given to the taxpayer before initiating proceedings for reopening. This full stop. Thereafter, the third notice under section 148 capital A within bracket small b of the Act dated 13/3/2023 was issued. However, we prime facie find there is no reference to any of the replies submitted by the appellant to the first two notices issued under section 148 capital A within bracket B. In the third notice dated 13/3/2023, an additional ground has been raised with regard to the alleged cash loan of rupees 62, 10, 00, 000. It is a submission of the submission made on behalf of the appellant that in the annexures to the said notice, a working table has been given from which the total amount is rupees 1, 50, 00, 000. Apart from that, it is pointed out that the assessee has subsequently come to know that in the order of approval, which was passed by the learned commissioner under section 151 of the Act, no approval appears to have been obtained with regard to the second issue, namely with regard to the alleged cash loan of more than rupees 62 crores. In our view, these issues.
One intelligence, madam. This approval issue was not raised before the writ court, my lord.
Before us.
Before, my lord.
These issues, in our view, in our opinion, are jurisdictional issues which need to be gone into in the writ petition, for which affidavit is essential. Affidavit has to be filed by the respondent department. Therefore, the writ petition should be restored to the file of the learned single bench to be heard and decided on merits after affidavit is filed by the respondent department. Accordingly, the appeal is allowed. The order passed in the writ petition dated 5th June 2023 is set aside. The writ petition is restored to the file of the learned single bench. The respondent department are directed to file their affidavit in opposition within 4 weeks from date. Reply, if any, within 3 weeks thereafter. The writ petition be listed before the appropriate learned single bench after a period of 8 weeks. Till the writ petition is heard and disposed of, the order impugned in the writ petition dated 30th March 2023, passed under section 148 capital A within brackets small d of the Act, and the consequential notice issued under section 148 of the Act shall remain stayed.
Grateful, madam.
Next.
Item number 10.
It is the public respondent's appeal. I am the successful writ petitioner.
They are not here.
They were also not there before the Honorable Single Judge, despite notice on 2 occasions. Matter was thereafter heard on merits. Very short compass, only one point of law, whether a change of name of a company essentially amounts to change of any personality of the company. It doesn't. I had a clearance from the Pollution Control Board in the name of my previous avatar. Subsequently, I obtained a change of name and I got a fresh certificate of
None appears for
incorporation.
the appellant. Dismissed for non-prosecution.
Obliged, Your Lordship.
Item number 11.
My lord, I am for the petitioner. Actually, pray for not this week. Since the council engaged the matter, due to certain personal difficulties, not a position to come.
I have it on 4th October or 11th October.
4th October, my lord. Grateful, my lord.
At the
Grateful, my
request of the learned advocate for the appellant.
My lord, my lord, kindly 11th, because he is having some
11th October.
11th. Grateful, my lord. Grateful.
Item number 12,
My lord, I appear for the appellant. My lord, this is in respect of an order, my lord, which has upheld the decision of, my lord, forfeiture of security deposit and blacklisting in a tender matter. Now, my lord, the reason why we are aggrieved is we are aggrieved more with the decision of blacklisting than the forfeiture. My lord, before showing 3 documents only, I'll show. Before showing the documents, my lord.
Respondent served.
Yes, my lord, we have served. Huh? My lord, in fact, my lord, they had appeared, my lord, we have a limited interim order. We were allowed to participate in future tenders with the copy of the order. My lord, this is the order dated 15 September 2023. Legion.
But we need to hear the appeal. If an interim order is granted, virtually tantamount to allowing the appeal.
No, my lord, what is happening is
Blacklisting cannot be stayed. If suppose there
No,
is
my lord,
invoking of or forfeiture of some money or something like that, some interim order can be
no, my lord,
balancing the
here,
interest.
here lordship will find the reason why, my lord,
No
lordship,
scope for interim order, Mr.
lordship,
Satish.
my lord, lordship will appreciate, my lord, it is not only a question of blacklisting in a particular department. Because of
Obviously,
this,
stigma will
my
come
lord,
along with you.
blacklisting, my lord, lordship knows, my lord,
We can, what we can do is, we can give an early date for the appeal, probably 22nd, 23rd. of
whenever lordship wants it.
23rd of November. Question of granting interim
No, my
order.
lord, only this limited protection, my lord, let me participate in all the other tenders.
Unless the stigma is
My
removed.
lord,
it can't.
lordship will then see 2 documents, my lord.
No, no.
My lord,
he
before
can't
refusing, my lord,
He can't extend the interim order. This tantamounts to allowing the appeal.
no, my lord, lordship will see 2 things, my lord.
Obviously, sir, it
My lord,
definitely
my lord, the
tantamount.
decision,
An identical order was set
my lord,
aside.
may I
Reassessment.
just show your lordship 2 pages? Kindly permit me to show 2 pages if lordship, my lord.
This order cannot be extended. We will hear you afresh. We will list the matter probably on 11th.
But the
October.
decision has not said that you blacklist me, but when the communication is coming, it is. Well, lordship just has a look at 1 page, madam.
There
Kindly, madam.
cannot be an interim order.
Well, kindly have a look at page 157 once. Madam. Kindly have a look at page 157. I am showing the decision which was before the learned trial court. Kindly have a look at that. The show cause doesn't say that I will be blacklisted. The decision doesn't say I'll be blacklisted. When the communication is coming, my lord, I am being blacklisted. (157) the order starts, point of determination, kindly come to 160 with reason. L1 whose candidature stands rejected, being the tender rules, entire tender process is cancelled, fresh tender be invited, so and so. The decision doesn't say blacklisting. My lord, I show your lordship the show cause notice. Because, my lord, Supreme Court has said that blacklisting is civil death. You have to give a show cause before and stating that.
Oh, you have got a good case on merits.
Yes, my lord, but in the meantime, I can't participate in any tender. Now, lordship just sees the show cause notice, page 125.
No, the decision with reason at page 160.
Yes.
What does it say?
It doesn't say anything about blacklisting.
Then where?
But when I am communicated, kindly see the communication. The impugned communication is page 132, 16th May. Wait,
132, 16th May, reference also.
132 is 16th May.
No, 132 says.
I'm sorry, my lord, 133. I made a mistake. 132 is, my lord, I was called, my lord, lordship will find, my lord, There is nothing mentioned that it is regarding blacklisting. Similar is the letter of 125, 133. I'm sorry. 30th June.
Therefore, in the light of the above, as per clause 6.5.1, for the e-tender document, your MD is forfeited and your BAT is barred from participating in future bids for 5 years. Where is clause 6.5.1.
Clause in the clause it is there. In the clause it is there, but
therefore you have got an excellent case saying that this barring you from participation is never put to you on.
There are two things, as per the Gorkha judgment, Lordship knows that because blacklisting is a civil debt, even if it is there, if you are contemplating blacklisting, the show cause notice must specify that you are being show caused.
How did the learned judge non-suit you on that ground?
Yes, the learned judge has held that the very fact the hearing was given and the consequences otherwise provide that you might be blacklisted. Therefore, you should be aware that the consequences can be of blacklisting. But that is not what, the Supreme Court is saying, kindly see the judgment of the learned judgment. Kindly takes the memorandum of appeal.
We will hear the appeal on 22nd or 23rd. 22nd, we will hear the appeal.
Lordship will only do this, I am undertaking, in terms of the limited order that I have got. If I participate, I lose in the appeal, I'll indicate to all the.
This is tantamount to allowing the appeals. Or if you want us to release the matter, we will release.
No, it is not that.
And as a senior counsel, you know better. So.
It is not my endeavor, to ask the bench to release it. That is not, Lordship will not take me amiss.
We have heard the learned advocates for the parties. This appeal is directed against an order dated 6 September 2023 in WPO number 1434 of 2023, which was dismissed. The appellant had challenged the validity of cancellation of a tender, forfeiture of EMD, and also the order preventing / barring the petitioner from participating in future bids for 5 years as per clause 6.5.4 Roman 4 of the e-tender document. When the appeal came up for admission before the division bench on 15 September 2023, an interim protection was granted to the effect that the appellant will not be prevented from submitting any tender, and the balance and the limited interim order will be valid till 22nd September 2023 or until further orders, whichever is earlier. And further, the learned court, further the Honorable Division Bench observed that the impugned decision dated 30th June 2023 or the impugned judgment and order of the learned single bench will not be a bar to submit any bid. A bar to the appellant to submit any bid should the appellant be able to obtain any stay of the impugned judgment and order and the said impugned decision dated 30th June 2023 by 22nd September 2023, the bids received by the appellant shall in no manner be processed by the respondent department. After hearing the learned advocates for the parties, we are of the view that if any interim order is as prayed for is granted in this appeal at this stage, it would tantamount to allowing the appeal at an interlocutory stage, which is impermissible under law. The learned advocate appearing for the appellant would contend that the order blacklisting the order barring / preventing the appellant from participating in future bids for 5 years by order dated 30/6/2023, impugned in the writ petition was without issuing any show cause notice and without providing an opportunity to the appellant, and the order is in total violation of principles of natural justice, and in this regard, the learned advocate places reliance on several decisions of the Honorable Supreme Court. Further, it is pointed out that in the resolution of the committee of the respondent department adopted in the meeting held on 24/5/2023 does not speak of any blacklisting or preventing the appellant from participating in any of the future tenders invited by the respondent authorities. In our view, these are all issues which has to be argued at the time when the appeal is being heard. And if any interim order is granted, which would have an effect of allowing an appeal at the interlocutory stage, would be impermissible. Therefore, the prayer for grant of interim order stands rejected. Since urgency is pleaded by the learned advocate for the party, the appellant, let the appeal be listed under the same caption. No, appeal be listed for hearing on 22/11/2023. Full stop. Since all the relevant documents are available in the stay application, filing of informal paper book is dispensed with. Next.
Item number 13.
But I appear for the respondent, my lord. My lord, item number 13 and 14. Learned additional searches is happening for the appellant. My lord, due to personal difficulty, he is unable to come. But I'm praying for not today, my lord.
Not today. At 13
Grateful,
and 14.
My lord, 13, 14, both matters are similar. my lord.
It is submitted that the learned additional solicitor general is appearing, and request is made to take up the matter on some other date. List on so and so date. Whatever date you want it.
4th of October.
Intercourt appeals, item number 15.
Please, your lords. Instead of 4th, may it be 5th, my lord. Instead of 4th, may it be 5th, my lord.
My lord,
13, 14. Grateful, my lord.
Time chhada jai chahiye.
my
Yes,
lord,
sir.
This is my application.
my lord, this is my appeal, my lord. Appeal not admitted, my lord. Thereafter, my lord, I am led by Mr. Kishore Datta. My lord, kindly short pass over, my lord.
Some application has been filed.
My lord,
File of necessity because respondents is filing this application. My lord, kindly give me 2 minutes time.
my lord, only my lord, short pass over, my lord.
I'm going to pass on how.
My lord, pass over, my lord, kindly. My lord, appeal not admitted, my lord, at all.
Can
Then, my lord,
dismiss it.
my lord, only my lord, I'm
not
praying,
make my
I'm
application.
praying for my lord, short pass over.
Not today.
Not today. This is compelled me to file this application. Waiting since long.
I am an
My
82-year-old
lord, this is the institution. My lord, probably Justice Honorable Chief Justice must have heard the name of our state's father, Dr. Bidhan Chandra. Whatever my lord is saying today is a creation of his thought process.
I heard of
Salt Lake, Kalyani, Durgapur, Asansol, West Asansol Corporation. This is one of the institute, the Institute of Social Welfare and Management created by him.
College Street.
Now, my lord, this was the balance. His thought process was excellent. He balances board of director and trust to check and balance. Now, my lord, board of amendment has been made such a fashion when, my lord, the ex-minister who is in now in custody, he tried to take the full charge and amended in such a fashion the main object of the trust has been given a go by. Now, my lord, the honorable judge has saved this institution from being doing like the other state organization. Now, this is the destroyer is before my lord.
Now, the
Now, my lord, they are siphoning out this fund.
now your writ petition was allowed.
This is allowed. Now, my lord,
There is no interim order.
no interim order, but
In
the
this
bank
appeal.
is not hearing us. This money is being siphoned out.
Who's
Can you
who?
stop that?
Bank.
My lord, this is not the true fact, my lord. What my line
False,
is saying.
false
My
fact.
lord,
But this is the fact is
Oh, sir,
siphoning out.
if the no interim order has been granted in this appeal, then the order passed in the writ petition will have an effect
My lord.
until it is stayed or set aside.
Kindly clarify.
Can you make it
my
clear?
lord,
I will not.
short pass over, my lord. Mr. Doctor is the senior, my lord.
All right, pass over. We shouldn't put him in embarrassment.
Yes. I cannot stand in the way.
Next.
Item number 16.
May it please, Lordship.
Big matter, small matter.
But it's a small, sure. But what was there? There's one mistake note in the order. The assessment order is dated 30th May, 2023, and the writ petition was filed. The filing date is correct, note 28th June. So His Lordship was pleased to observe that the writ petition was filed after the passing of the assessment order and expiry of the appeal period. But factually, that is not quite correct.
Now, the assessment order, assessment order is dated 30th of March 2020.
It's 30th of May 2020.
30th of May 2020.
Yes, and the writ petition was filed on 28th of June. So within the appeal period, within the period available for preferring the appeal.
So on merits, it was not decided.
No, essentially the point which was taken was that.
But why the assessment order was challenged in the writ petition?
I'll just explain. This point, the assessment is 2013-14. The point which was urged, just a few lines about the factual background. This assessee is a tea manufacturing company, an old established concern. It had given in two tranches 8 crores interest-bearing intercorporate deposit. It got back the money with interest. Tax was deducted within the same year. The money was received back. That's 8 crores odd. Then it sold part of its tea to some trading concern for some 30 odd lakhs. This problem with those people, apparently it appears from the recorded reasons, but my assessment, my assessment is being reopened. I had originally filed a return of some 12 odd crores. It was assessed under section 143.3. So when this notice came, it came in 2021. So I explained these facts. Then I said it is also time barred. So this was in 2021. Then this notice was issued under the old provisions. The judgment of the Honorable Supreme Court came in Ashish Agarwal saying that it has to be under the new provisions. But then they issued me a notice under 148AB according to the Supreme Court judgment. Then in my reply, the objection which I filed, apart from merits, I also took the point of limitation. He decided that objection, but did not deal with my point of limitation. So there lies the root of the problem. He proceeded with the assessment without deciding the objection fully. The objection was not decided fully. He, in his own way, dealt with the merits. Although on merits, in my
that is also could have been agitated before the commissioner.
I can do that. That remedy is clearly there, but even that remedy has not been allowed by the learned judge. The writ petition has been dismissed. So, as I
can give you that liberty to go before the commissioner within 30 days.
I can do that, but I was just thinking that since the objection itself, if the objection had not been decided, then the assessment itself would have.
That is a good ground on which the order has to go in its entirety also, or the commissioner can take up that issue and decide whether the reopening is barred by time.
Of course, those grounds are definitely available. I cannot say that that remedy is not there.
We will vacate this observation and say you could not have been non-suited because factually the appeal writ petition was filed within the appeal time. So therefore, we will extend the time for filing an appeal for 30 days from the date of receipt of the server copy. You file an appeal.
I'm going to let the appeal be decided early. That case.
This intra-court appeal by the writ petitioner is directed against the order dated 2nd August 2023 in WPO 1340 of 2023. The said writ petition was filed by the appellant challenging a reassessment order passed under section 147 of the 147 read with section 144 of the Income Tax Act 1961 within bracket the Act dated 30th May 2023 for the assessment year 2013-14. The learned single bench had dismissed the writ petition on the ground that the reassessment order was passed on 29th March 2023 and the writ petition was filed on 28th June 2023, much after the expiry of the period of limitation for preferring an appeal as against the reassessment order and therefore the writ petition cannot be entertained. After hearing the learned senior advocate appearing for the appellant and the learned senior standing counsel for the respondent department, we find that a factual error has crept in while noting the date on which the assessment order was, reassessment order was passed. The correct date on which the reassessment order has been passed, which is not disputed by the revenue, is 30th May 2023. And admittedly, the writ petition was filed on 28/6/2023, well within the period of limitation for filing a statutory appeal as against the reassessment order. Therefore, the appellant could not have been non-suited on the said ground. Be that as it may, the principal ground on which the reassessment order has been challenged is by contending that after notice was issued on the assessee proposing to reopen the assessment, the assessee had raised a preliminary objection with regard to the limitation aspect, contending that the notice intending reopening the assessment was barred by time. Apart from that, the assessee has also raised issues on the merits of the matter. It is the contention of the learned senior advocate for the appellant that the issue regarding the limitation aspect, which was specifically canvassed by the assessee in their reply to the show cause notice issued under section 148 of the Act, was not dealt with by the assessing officer while rejecting the reply/objection filed by the assessee. In our considered view, this issue will not be a pure question of law, but would be a mixed question of fact and law. And therefore, it is but appropriate for the assessee not to bypass the statutory appellate remedy available under the provisions of the Act, which is not only an effective remedy, but also an efficacious remedy, as the first appellate authority could be entitled to appreciate and reappreciate the factual position. Therefore, the appellant should file a statutory appeal before the appellate authority, namely the jurisdictional commissioner of income tax within bracket appeals. In the light of the above, the order passed in the writ petition is set aside, and the appeal stands disposed of by directing the appellant to prefer a statutory appeal before the jurisdictional commission of income tax within appeals within a period of 30 days from the date of receipt of the server copy of this order. In the said appeal, the appellant is entitled to canvass all grounds both on facts as well as in law, and the learned appellate authority shall consider the appeal and endeavor to dispose of the appeal as expeditiously as possible, preferably within a period of 2 months from the date on which the personal hearing is concluded.
I'm grateful. But that my lords have permitted me to file within 30 days, but that no objection as to limitation can.
Yes, please come, sir. Since this court has directed the appeal to be filed within the time stipulated above, the appeal should be entertained by the learned appellate authority and decided on merits, and not to be rejected on the ground of limitation. We make it clear that we have not gone into the merits of the matter, and the appellant is free to canvass all grounds before the appellate authority, which shall be considered in accordance with law. I'm grateful. Considered on merits and in accordance with. I'm grateful. Thank you. Next.
Item number 17.
Yes, sir.
Actually, I'm for the appellant. At the very behest of Lordship, if I may humbly submit, the name is Din Bandhu Construction. In the list, it is Dina Bandhu. There's an extra A that has been added, Your Lordship. Lordship, by virtue of this appeal, I'm challenging, Lordship, the notices and the assessment order, which was issued in the name of a non-existing entity. In the writ court, I had challenged it, but only it was rejected because of the ground that the assessment order was passed. But Your Lordship, if I may humbly indicate, For the previous year, that is, this is for assessment year 15-16. For 14-15, the writ court had quashed the notices. Same assess, your lordship.
Where is the order?
Lordship, if I may, lordship, the order is at page 81.
No, where it quashed the.
Lordship, it quashed, it's at page 81, your lordship. That was for assessment year 14-15.
And Aryak, you have filed an appeal against that order?
No.
Till date, you don't file.
No, because the company is not existing.
Company got converted to LLP, your lordship.
And my lord, his lordship my lord, got very angry on the petitioner and dismissed this one. So this was
What mistake Siddharth did?
because he delayed in coming
Lordship,
to
the
court.
honorable judge said why you waited for the assessment
Because,
order to be passed.
The 48 AD order was passed, 148 AD order was passed on
Where is the
28.
impugned order?
So the impugned order is at, lordship.
For 148 AD order was passed on 28 July 2022. And he has come to court on this year. So by
No,
that
no.
time, the 147
You
order
will
was
see the
also
reasons.
passed.
Anjan, that memo of appeal is there.
Memo.
But anyhow, liberty was given in the earlier order.
My lord had not rejected. My lord had simply granted exchange of affidavits without passing a stay order.
All right. Assessment order was passed on 16th May.
16th May, your lordship.
Writ petition was filed on.
Petition was filed on lordship. I say.
You see the writ affidavit.
It was in July, your lordship.
All right.
But lordship, in my humble
We will grant an interim order in this appeal, dispose of the appeal. You file your affidavit in this intra-court appeal by the writ petitioner is directed against the order dated 22nd August 2023 in WPO 1450 of 2023, by which the learned writ court declined to grant any interim order in favor of the appellant on the ground that the appellant had filed the writ petition challenging the assessment order dated 16th May 2023 by filing the writ petition well beyond the period of limitation for filing a statutory appeal as against the said assessment order. It is pointed out by the learned advocate for the appellant that in respect of the very same appellant assessee for the assessment year 2014-15, an identical assessment order was put to challenge in WPO 1451 of 2023, and the learned single bench by order dated 22nd August 2023 had allowed the writ petition and quashed the assessment order for the assessment year 2014-15. It is submitted by the learned advocate for the appellant that the facts in the present case is identical, and the only difference being that the present appeal / writ petition relates to the assessment order 2015-16. In the light of the fact that the learned single bench has directed affidavit in opposition to be filed by the respondent department within a time frame and directed the writ petition to be listed in the month of December 2023, and we are of the view that since the appellant had the benefit of an order passed in WPO 1451 of 2023 dated 22nd August 2023, by which the assessment order for the year 2014-15 was quashed on identical grounds, we are of the view that the assessment order impugned the writ petition dated 16th May 2023 for the assessment year 2015-16 shall remain stayed till the writ petition is heard and disposed of. The respondent department are directed to abide by the direction issued by the learned single bench and file their affidavit in opposition. The appeal stands disposed of.
Lordship, if I may, one in my lordship, it's a non-existing. My lord can quash the entire proceedings. It's a
Public interest litigation, item number 18.
My lord, I appeal for the corporation, my lord. I pray for justice, my lord, one more time, my lord, because.
No, no, my lord, this will continue forever. If my lords are
Because he was,
pleased to, my lord,
was pleased
grant
to
time,
ask
my lord,
us for
I
us
have
to
nothing
submit
to
a
say.
report.
But kindly see the last order, my lord.
No, no, that is the reason
draw
I,
your lordship's kind attention to
order
the
is
last
before
order.
me.
Kindly see.
Your lordship asked one to submit a report in the form of affidavit as to the status of implementation of the Street Vending Act.
And in the name of implementation, this will continue forever. Since 2014, it is going on.
Every day we are reading in the
So
paper.
that's right, my lord.
The other day also, the service road in Newtown has been completely taken over. And for almost 1.5 to 2 kilometers is full of this, street food vendors. They have put up tables, they put up, pedestal fans, and a huge cooking range is there. And all your aloo posto and your luchi is being fried and people gobbling up.
And now puja is coming, my lord.
And now one state says dengue, and you have cancelled the leave for 1 lakh of the health sector employees.
My lord, kindly see page 15 and 16 of the writ petition, my lord. The photographs are there.
And no, this is not a new problem,
Yes.
sir. Now, once I think another single bench is monitoring another matter. Today's newspaper says they have been pushed back, and pedestrians can walk during puja for purchase.
But that's not the point really, my lord. We need to do much more.
Yes.
My lord, I have
That
an affidavit here.
Maulik Bazar, that is clear now. I think now it is clear.
Yes.
In between, once again, vehicle dismantling took place. Then the KMC took action, police took action, then it's gone.
My lord, Maulik Bazar is famous for other things also. Stolen properties being sold.
So now after this.
No, my lord, why I am referring 15 and 16, whether the photographs will make it clear that this is going on, my lord, just beside the my lord, the head office of Kolkata Corporation. The SS Hog Market is
there. It is with their blessings.
Yes.
What is this, sir? You see page 15 and see how your officers will enter KMC office.
Yes, that is the question.
And there is another, I don't know that, she's a young lady who runs a restaurant on the footpath. I think it's somewhere near here.
ইউটিউবে অনেক ভাইরাল আছে স্যার ওর রিলস গুলো খুব ভাইরাল আছে ফেসবুক আর ইউটিউবে নন্দিনী her name is Nandini.
Indrani আর তুমি বলছো
Nandini.
It's there in the YouTube.
Your lordship's court officer said Indrani. I was corrected by the authority. That is
And
Nandini.
there is another video uploaded that recently she has been given an award by the Rotary Club for providing, I don't know, good quality food on road margin. And there is another video uploaded where she physically assaults 2 people. She physically assaults who are much elder to her. See, these things pop up automatically, depending as AG was mentioning. No, you are somewhere you searched for some walking shoe or something like.
Yes.
Next day you get message saying you come buy this Nike 50% off, Adidas 50% off. Sir, this is very bad. In front of your office, how you can?
My lord, not only for the pedestrians, but my lord, it also endangers the public life. My lord, in such a manner, the cooking and all that, my lord, those are.
But here also you are frying.
Yes. Yes.
Other day we went to bar room number 5. There's a full.
Yes.
4 burners.
Yes. My lord, corridors itself, my lord.
Yes, corridor only I am.
Yes.
That was for what puja or no? Not puja.
My lord, must be Ganesh. My lord.
No. For portrait.
Portrait unveil.
5-6 times I have been there. Twice live cooking counters were there. Other times it's either boxes or some sweets are given. This was full-fledged lunch. sabji being made there. When you're a member of Bar Association or Bar Library Club?
Bar association.
Bar Association. So you are party to that. So how you can argue this case?
No, my lord.
Sir, do something, sir.
No, no, that's where Your Lordship's direction, my lord, regarding the implementation of that particular act. And Your Lordship also directed us, my lord, to regarding the status as well as the implementation.
The other
This is
day,
the-
I wanted to buy a shoe because something happened to my shoe. What is that hotel, sir? Huh? Great Eastern. No, another hotel. Oberoi. No. Oberoi Grand.
Grand Hotel, Grand Hotel, Grand Hotel.
Yes.
Grand Hotel. Huh?
Grand Hotel.
There are a lot of shops also.
Yes, my lord, that pavement, my lord.
You cannot enter. And fellows are virtually thrusting some handkerchiefs on me.
Yes.
That market, we have also seen. There is one place in T Nagar in Chennai. It's called Ranganathan Street. People cannot walk. Like you stand in a place, you will be automatically carried.
By the way, my lord.
Yeah, it also you need not walk. But here, these vendors virtually prevent you from entering the shops. And they have got their shandies or thing up to at the height of 6 or 7 feet. The board of the shops are not visible. And we have to enter in that corner. Your car can't be parked, your two-wheeler can't be stopped there.
And my lord, what your lordships are probably not aware of, you know, there are many eviction proceedings against the people who are who have shops there.
Okay. That is also
That is
paid.
also there. My lord, because Grand wanted, my lord, the entire thing back. Leases have expired.
And we have been hearing one matter, Public Premises Act, LIC building.
Yes.
That's in Park Street. What is
Correct.
it?
Queen's Mansions.
How many years? Mr. Mitra only has argued on a preliminary issue. Estate officer is still yet to open up the matter. 22 years of litigation, 1,200 rupees rent. So what to do, sir?
What is
My
my
lord,
authority
sir,
should,
if
my lord,
there is a will, there is a way.
Yes. Yes.
If there is a political will, that definitely it can happen.
My lord, the judgment was.
I was a party to a decision where in the Marina Beach, unregulated vendors were there. There will be like 1,000 fish stalls. Even if you don't eat fish, they will stuff it on you. So that, but still there was a political, in spite of an order passed at the court, it was not implemented. Thereafter, there was a political will. Now the whole thing stands regulated. Because people who come to the beach from various parts of the country, they'll spend a lot of time, 6 hours, 7 hours. So obviously they require some food. So it can't be scattered here and there. There are people who have sunk borewell in the Marina Beach.
I've seen, my lord. I used to go there whenever in Chennai, my lord. Morning walk was, my lord, along the promenade. My lord.
And this borewell is, you get very good water, though it is on the beach. And you within 300 meters is bearable. Inside the shop, they have dug the borewell. And now it is regulated. The canopy which they have provided is of common design. But still, once again, the problem is there. But unless you are elected members, your honorable mayor, everybody takes a decision. Any amount of order is not going
Exactly, that's the point. Because Supreme Court has passed its judgment in the year 2014. Statute was, my lord, enacted 2014. No, judgment was in 2013 and the statute was enacted in 2014. And my lord, this is the third round of litigation. After the first round of litigation, my lord, it was assured by the corporation, Kolkata Corporation, that yes, it will be implemented. Nothing has been done.
Even
Then
now they
second-
are saying it will do.
No.
When, why, who will do it, we don't.
My lord, after second round of litigation, it was placed before the Assembly House and the rules has been framed. Rules have been framed. Then, my lord, it was assured that yes, now it will be implemented. Nothing has been done. And now this is third round of litigation. Still,
All right, what do you want, sir, now?
well, I submit to your lordship, my lord, because your lordship directed specifically upon my authorities, my lord, to file a report in the form of affidavit as regards the status of implementation. Therefore, that is to be done by them. Therefore, some information I have obtained. But my lord, I do not want to disclose right now because they are to state on oath before the Lordship's court, my lord, that what they implement, they want to, my lord, the
Already,
submit before
in
Lordship's.
the interregnum, can you not do something about this in front of your headquarters?
Well, I'll tell them, my lord.
Already 3-4 reports have already been filed. I have filed exception to that. Ultimate result is 0, nil.
All right, we will, because learned advocate is pleading some inconvenience.
My lord, I have my lord report, my lord, in the form of an affidavit. My lord, unfortunately, my lord, it's second copy to my lord, the second copy, my lord, I'll give my copy, my lord. We'll have it replaced, my lord, because my lord, only one, my lord, was prepared. My lord, for some unknown reason. My lord,
But in this report, there is
my
there.
lord, I'll tell your lordships, my lord, what has happened. My lord, I'll tell your lordships. My lord, as far as my lord, the urban bodies, my lord, are concerned, my lord, in all 128, the urban local bodies, my lord, town vending committees have been now constituted, which wasn't, my lord, there. Then, my lord, second thing, my lord, which has happened, apart from, my lord, meetings being held, my lord, vending zones, my lord, have also been identified. Third, my lord, heritage markets have been identified, natural markets have been identified, and my lord, these have all been declared. But, my lord, apropos the vending zones, my lord, the declaration, my lord, is yet to come. My lord, I would request your lordships, my lord, to give a direction that declaration, my lord, comes, my lord, within a, my lord, particular period, 6 weeks or, my lord, whatever, so that the declarations come. Because once, my lord, the declarations are there, my lord, a survey is being done, my lord, with regard to.
And who has to issue the declaration?
My lord, the local authority.
So based on the town vending committee's report,
Yes.
they will have to issue a declaration.
Yes, my lord, and I've given, my lord, that at page 35, your lordships will find, my lord, report of identification of vending zones. My lord, this has, my lord, happened. Copied each one.
But this town vending committee, was there exercise just to regularize all these encroachments?
No. Because, my lord, the act, my lord, as I read it, my lord, is, my lord, street vendors, there'll be a survey, my lord, to find out and where they are. My lord, we have, my lord, the heritage market, which has been declared, natural market, which has also been declared. And then, my lord, we have, my lord, vending zones, which have to be declared. Survey, my lord, is done of the street vendors. And, my lord, they are, my lord, then allocated, my lord, the vending zones. So, my lord, they have to go, my lord, to the vending zones. Certain areas, my lord, will be no vending zones. So, my lord, after the survey is done and, my lord, the street vendors, my lord, are then, my lord, given an identification, my lord, certification, my lord, they have to, my lord, go, my lord, to that particular vending.
So for which an order has to be passed by the concerned district magistrate?
No, my lord, the local authority, my lord, has to first pass an order.
The municipality, corporation,
Correct.
panchayat.
It's really, my lord, local, my lord, urban local bodies, my lord, because, my lord,
in this report,
yes,
you have mentioned about that page 6 of the report.
Yes, now, my lord, kindly come to
Lordship,
page
local
6.
authority has been defined, my lord.
Declaration of the vending zone is being made by the urban local
My lord, it's
bodies.
being made. My lord, so I checked. My lord, is in process. My lord, they're having meetings. The declaration has to come. And your lordships, my lord, will find that, my lord, in the act, as well as the rules, my lord, the definition of a vending zone, my lord, is given.
So they have to issue a declaration that this is the vending zone, this is no vending zone.
Yes.
And that has to be implemented.
Correct. And, my lord, the street vendors then, my lord, who are, my lord, all over the place, my lord, they have to, my lord, fit into the, my lord, be fitted into, my lord, the vending.
Enforcement is what is very important.
Correct.
Vending certificate দেবে তারপর তারা
Correct. Now, my lord, your lordships will find vending zone, my lord, is a area or a place or a location designated as such by the local authority. And, my lord,
At page 24, my lord.
and local authority, my lord.
For today, we issue a direction to the urban local bodies to issue a declaration pursuant to the report submitted by the town vending committees
Yes.
for 104.
Correct, my lord, out of 120.
128. So in respect of the balance, urban local bodies where
That's 24 more, my lord. Kindly give them, my lord.
24 more, the town vending committees, respective town vending committees will identify
Correct, correct.
vending and no vending zones.
Yes.
Then in respect of this 104,
yes,
in respect of 663 vending zones,
Yes.
In 104 urban local bodies,
Yes.
the concerned urban local bodies shall issue a declaration
Correct.
within 3 weeks, demarcating the vending and no vending zones, and that to be implemented. So far as KMC is concerned, we will give them some time.
Fine.
And the encroachment before your office, you please clear it.
Lordship, can we let there be a my lord time span, my lord?
3 weeks.
3 weeks. Oh,
My lord,
okay.
kindly make it 4, my lord, 4 weeks, my lord,
Okay.
instead of 3. My lord, I'm being requested, my lord, to make it after pujas, my lord. Kindly give them, my lord, time beyond pujas, my lord. Otherwise, my lord, if people can't bend, my lord, by then there'll be a problem. My lord, kindly.
Advocate appearing for KMC. We put within bracket KMC before. KMC prays for further time to file the affidavit as full information is yet to be received by him. The learned Advocate General has filed a report in the form of an affidavit filed sworn to by the Special Secretary, Department of Urban Development and Municipal Affairs, Government of West Bengal. In the said report, the steps taken by the town vending committees has been mentioned, and it is seen that the town vending committees in 104 urban local bodies have identified and recommended 663 vending zones. And in respect of the remaining 24 urban local bodies, the process is on. In terms of the provisions of the street vendors, within bracket protection of livelihood and regulation of street vending, bracket close Act 2014, the recommendations made by the town vending committees has to be considered by the respective urban local bodies, and a declaration has to be issued clearly demarcating the vending and non-vending zones. This appears to be in the process of being done, but is yet to be completed. Therefore, we would direct the respective urban local bodies to issue appropriate declaration after considering the recommendations of the respective town vending committees, which are said to have identified 663 vending zones in 104 urban local bodies. The recommendation should be properly scrutinized, and upon consideration of the provisions of the Act and the other and the rules framed thereunder, a declaration be issued by the respective urban local bodies within a period of 6 weeks from the date of receipt of the server copy of this order. Upon such declaration being issued, the authorities have to ensure that the street vendors strictly abide by the declaration, and vending can take place only in the identified zones, vending zones, and no vending shall be permitted outside the authorized vending zones. With regard to the 24 urban local bodies in which the town vending committees are yet to identify and recommend the vending and no vending zones, 6 weeks time is granted to the respective town vending committees to complete the process and make their identify the vending and no vending zones and make their recommendation to the respective urban local bodies, which shall issue the declaration after considering all the factors within a period of 4 weeks from the date on which such recommendation is made in respect of the 24 urban local bodies. Full stop. The learned advocate for the petitioner had pointed out that in front of the head office of the Kolkata Municipal Corporation, the entire road has been encroached and vending is being carried on. It is not clear as to why the Kolkata Municipal Corporation has not taken any action to regulate the vending, more particularly in front of its head office. And from the photograph annexed to the writ petition, we find that the entire road is occupied by vendors displaying their articles made available for sale. It is rather unfortunate that such a situation is prevailing under the in front of the head office of the Kolkata Municipal Corporation, which authority is expected to ensure that the streets and public places are kept free from any encroachment. Therefore, the Commissioner of the Kolkata Municipal Corporation is directed to take appropriate steps, at least at the first instance, by clearing the encroachments in front of their head office. As requested by the learned advocate, by the advocate appearing for the Kolkata Municipal Corporation, the time for filing the affidavit by the corporation is extended by 3 weeks from date. List the matter on 6th of December.
Well, Lordship, subject to Lordship's consideration, whether may I pray for an interim order for this puja period, my lord, to my lord, so that the state machinery, my lord, becomes more active for the more congested areas.
But there is a frenzy, sir. That is very difficult. Very difficult. You go to the Pandal, so many people are there. It can never be regulated. That from Mahalya till I think Ashtami, up to Dashami, up to 24th.
My lord, till Bishorjan, my lord, because my
Yes.
lord, the parade also happens.
Yes. List also. Next.
I am grateful.
Second copy हम रखिए.
My lord, we'll replace, my lord, the second.
Item number 19.
Your Lordship. Yes, sir.
Ramo is matter, my lord.
Tramways, yes.
Lordship's last order made in June, my lord. My lord, 3 words, my lord, will summarize the essence
One
of the order.
committee was constituted.
Yes.
Yes.
My lord, the
Committee was
minutes were to be
constituted.
placed, my lord.
What I'm trying to submit, my lord, the 3 words in your lordship's earlier order, my lord, which will summarize, my lord, the essence of the order, my lord, to restore, maintain and operate the tramway. My lord, the committees, my lord, are supposed to bear this in mind, my lord, in all their deliberations.
Whether the meeting of the committee has been
One meeting of the committee has been held, my lord,
minutes,
but
my lord,
lordship will kindly look at the minutes, my lord. My lord, what is their desire to carry out your lordship's order, my lord, and give effect to it. My lord, lordship kindly, my lord, sees, my lord, the committee's report, the first report of the deliberations of the committee, page 2, my lord. Yes. My lord, lordship kindly comes to page 2. These are the members of the first page, members present. Committee form pursuant to lordship's order. Page 2, paragraph 6 is the government stand, my lord, summarized.
Why did the petitioner object to the presence of two representatives of the Heritage Commission?
Order specifies only 1%.
The order, lordships order.
The petitioner had been put in the committee
Yes,
so that some constructive suggestion could have been made.
that
If
is,
the petitioner is trying to put a smoke in the committee, she will be removed from the committee. And every other person has spoken something useful,
Yes.
and the petitioner did not even have the courtesy to first make a submission where what was sought for in the writ petition, but to put a smoke.
No, no.
my
I
lord,
was-
Then if it is going to be of a nuisance value, the petitioner will be removed from the committee.
Yeah, but
no, no,
Let the petitioner decide. Sir, when we make a submission, how do you make a submission in open court? First, you make the best points before it. You are before a committee and the petitioner has a duty. The petitioner has been included by the in the committee by the court order,
that
and
is
she
true.
owes a duty to the court.
Lord, what is falling from your lordship? I
No, no,
believe,
that
Lord,
is
the
this is in
petitioner-
bad taste.
Petitioner will bear this
And
in
the
mind.
first meeting of the committee, I come and say, no, 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 sir, you shouldn't be in the left. You shouldn't be in the right. What sort of this? We will not take up the matter.
My lord, your lordship.
No, no, not at her instance. We're thoroughly disappointed. Thoroughly disappointed, Mr. Lahiri.
My lord, I
As
believe,
a
my lord,
senior advocate, you please advise her. Advisor.
I'll take it to task. my lord,
There
and,
is a
my lord,
ways and means of doing it. And he purposely put that on minutes,
okay.
probably. And
My lord,
and you say
my lord, I
presence
personally-
of Mrs. Kakkar is also objected.
my lord, I personally tender my apologies. to
No,
her.
no, no,
My
no.
lord, I
Let an
give
affidavit be
regard
filed.
to her, my lord, my
And
lord,
how
lack
do you
of
think, how do you
experience
think,
and
see,
long
then
age.
nothing fruitful will happen. And Mr. Pradeep Kakkar or the earlier the joint managing director has also said, everybody says, or Kakkar has said that the role of the government is very, very important. Obviously,
That is
without their support, you can do nothing.
Yes,
You
that
can do nothing.
that is so. my lord. That is so. my
Your
lord.
role should be productive, sir.
That is so.
Your role should be productive.
I believe, my lord, in future, my lord, the
And
petitioner.
it's not, yeah, the writ petitioner is not a naive junior who enrolled last week and it's before this court. This is in very bad taste, sir.
That is so.
Personally
I-
speaking for me, I have been part of such committees. I worked with the Greater Chennai Corporation in several matters in garbage disposal pursuant to orders passed by the then Chief Justices of the Madras High Court. It is with the utmost humility you have to approach the organization.
My lord, that is so.
Not thinking that because of my writ, we will discharge the writ petitioner. You continue to appear, we will discharge the writ petition.
My lord, lordship will kindly not do so, my lord.
No, we
Lord,
will
I-
discharge the writ petitioner.
My lord, I
We will
tender my
treat it as a
apologies.
suo motu PIL.
My lord, I tender my apologies, my lord. In the petitioner's conduct has hurt your lordship, my lord. I have taken her to task. I have explained to her, probably it's due to her, my lord, lack of experience and young age. Lordship will kindly excuse her.
I can at least perceive what would have been the temper or what would have been the atmosphere in the committee when such objection
That
is
is so.
raised. These are all to derail the proceedings. And what is the objection for the member representatives of the Heritage Committee? What has the petitioner got to do?
Well,
Let us
she-
see the composition.
My lord, she used to assist the committee, my lord. As a fallen from
No,
your
no, what
lordship.
is the objection? Presence of two representatives. What is the expertise the writ petitioner has on heritage? Please let her disclose her credentials.
My lord,
Let her
Okay.
file an affidavit of apology, then we will take it up.
Right. Right.
We have perused the report, we have perused the minutes of the meeting of the first meeting of the committee constituted by this court by order dated 7th August 2023. On reading paragraph 4 of the minutes, we are saddened to note, though the writ petitioner was made part of the committee with the object that the writ petitioner will extend assistance, it appears that the writ petitioner has not even opened the subject, but raised preliminary objection with regard to the presence of two representatives of Heritage Commission as well as the presence of Mrs. Kakkar. The petitioner should realize that she has been included part of the committee on a prayer made by the learned senior counsel who is appearing for her. And she is be a member of the committee pursuant to a court order, and no vested right accrues in favor of the petitioner. If the petitioner realizes her role let the writ petitioner file an affidavit before this court, after which the court will consider the matter and pass further orders. This is the matter, 3rd week of December. Next.
Milord, would the Lordship will excuse me, Milord, may I make only one submission? Milord, we will file the
Sir,
affidavit.
we have not come from anywhere, sir. We have not jumped from there. Nobody, see, do you think an advocate has got all the expertise?
No, Milord, I
Mr.
believe-
Arindam Lahiri is a special officer. He appointed in National Highways matter for 5 years he is appearing. Do you mean to say that he knows about the roads?
No, Milord, it
No.
doesn't.
But
It doesn't.
out of his own efforts, he has done it. Therefore, the petitioner should realize that court has put her. So with utmost humility you approach. What is your object? Object is to preserve, restore and maintain. Restore, preserve and maintain the tramways, not to show the might.
Milord, we shall come up with the affidavit, Milord, it has fallen from your Lordship. Milord, would you
Very
Lordship-
sad, sir.
Milord, having due regard, Milord, to the Milord issues involved, Milord, to Lordship, can you take it up?
Yes,
Milord?
yes, let it come.
In
sir.
the first week of October,
There are people who will come and deal with the matter. There's no problem at all. Whether trams are there or trams are not there. As a person from
Milord, I
Kolkata,
shall come up with
it
the
is your
affidavit.
touch.
Milord, I seek
It
this
is-
personal.
It is the court took upon itself this responsibility. And you imagine, sir, how the other people will respect the court order.
It is so. I'm respectful agreement to
See, a
fallen from your
committee is
Lordship.
constituted for the purpose of taking forward things. It is not the first place where you show your ego. Yes, I am the writ petitioner. What have I done? I have dragged you here.
Milord, will come up with the affidavit.
Yes, yes.
Matter,
Never I do these things. In these 14 years, I have never appointed an advocate commissioner, even for physical verification. Sitting in the appellate court, I have reversed orders passed by the learned single bench, saying that a member of a noble profession should not be exposed to such unnecessary danger. He is saying that go and see whether there is an encroachment. Suppose he gets beaten up. There is some violence takes place. Who's to protect him? But at the request of the learned senior counsel, we acceded to that. And he puts it in black and white, that objection. Next.
specialist fixed matter, item number 20 to 23.
My lord, here, my lord, I appear for the appellant. My lord, it's come for hearing, my lord, but my lord, can't.
Not ready.
No, my lord, he's with me. No, because, no, correct. My lord, I accept that, my lord. Wherever I'm there, my lord, when I look right or left, whoever are my juniors, my lord, are relaxed. Because they said, this one person would have read the papers, we don't need to.
Well, over the years, we have learned to be relaxed when Mr. Mukherjee is our senior.
Hearing bench. That should be.
There should also be, my lord, a residuary bench for motions. But we are facing this on a day-to-day basis. My lord, residuary determination. My lord, there is only one bench. The bench is completely overburdened, and there is even civil division. My lord, kindly
Both,
give
both.
2 motion benches.
My lord, there
My lord,
are queues, my lord, which are, my lord.
the learned judge is so overburdened, mentioning is only on one day. And on that day, my lord, there are more than 1,000 people that gets into the courtroom. And my lord, there's a specific indication in the list.
Saturdays also. Those the dates. Because we have split up work, but certain places, it is not up, what do you say, up to your desired speed. What to do? We can drive only to that extent we are capable of driving.
Well, like they have in the Supreme Court, well, a motion for at least 2 hours in the morning, first half, or till at least 12:30, if some benches are assigned to just hear motions, irrespective. So, well, that will.
In fact, that exercise we have done, we have split up the list distributed within 4 judges. Then Supreme Court directive, 20-year-old cases that also 11 benches are dealing with, irrespective of determination. Apart from that, sickness, at least 3-4 falling sick this dengue season. All right, let it remain in the list.
May I just indicate one thing, Malad, with the leave of Mr. Mukherjee? Malad, there are total, if your lordship will see, there are total 4 appeals. Malad, the first 2 appeals were heard and had the same point. Malad, what the learned judge did by the impugned order, Malad, the first matter was heard and the other writ petitions were disposed of along with that. So, Malad, one matter where this is a willful defaulter matter, a person who was not even a director, Malad, your lordship passed an order segregating that, said that you go and file a review because that was not taken.
What happened?
Malad, in respect of the third and the fourth matter, item number 22 and 23, situation is the same. No, that can also be segregated, and if your lordship gives us leave, we can file the review. Because
what happened to the other review?
Well, that's gone before the learned single judge. A review application has been filed. It has been heard. So, item number 22, 23.
It is APOT 44 and 45.
My lord.
Have you got a copy of that?
Yes, we have. Well, this is the copy of your lordship's order that your lordship passed, by which the 5th appeal was segregated and sent back to the learned judge. অন্য দুটো হ্যাঁ এই দুটো তো করতে হবে ওই দুটো তো কনসিডারই করলাম
So liberty was granted to file review in WPO 26.
My lord.
And what will be the writ petitions here?
My lord, the writ petitions will be in APOT 44 and 45.
WPO number?
Yes, I'll tell you your lordship the writ petition now. Into not of the Dhamma. Give the. Well, one would be WPO 24 of 2021. Well, this would be in respect of item number 45.
Item number, no, APOT 45.
I stand corrected, not APOT 45.
All right. Another WPO?
And the other would be WPO 20 of 2021.
That relates to item 22.
That is, my lord, item 22, APOT 44.
Respondent, your appeal.
Lordship, I am led by Mr. Joy Shah.
We will grant a similar liberty. Let them file they have already filed a review in the other one. And the appeals were disposed of, no?
The order appeals disposed of.
Yes, my lord.
We have heard the learned advocates for the parties.
Yes.
In these, this is a common order in APO 44 and 45. These appeals are directed against the common order passed in WPO 24 of 2021 and WPO 20 of 2021. You make it ulta, 20 of 2021, 24. Against the said common order, 5 appeals had been filed. And in APO 46 of 2023, the appeal was disposed of with the observation that if the appellant, with the leave of the learned writ court, files a review application, the learned writ court was requested to consider the matter on merits and in accordance with law. The said order dated 5/5 said order has been complied with by the said appellant, and a review petition is stated to have been filed. The learned advocate appearing for the appellant prays for an identical liberty in these appeals as well. In the light of the above, these appeals are disposed of by on the same lines as that of APOT 46 of 2023 dated 5th June 2023, with an observation that if the appellants, with the leave of the learned writ court, file a review application, The learned writ court is requested to consider the matter on merits and in accordance with law. Full stop. In the event the respondent bank desires to file an additional affidavit in opposition to the grounds raised in the writ petitions, leave may be granted to the respondent bank to do so. Accordingly, GA is also disposed of. What is APOT 177? That is different. Item 24.
Different.
Oh, sorry. That's
Unconnected.
So so we are left with two appeals, 33 and 34. They shall after vacation. APOT 33 and 34 after vacation.
Because your lordships granted an interim order also, my lord.
Item number 24.
Passover matter. This is the last matter. Yes, Mr. Rahim, what happened?
Lord, I'm in item 24. My lord, the appellates before your lordship, my lord, they have concluded their arguments. They argued, my lord, for about 8 days.
On the last occasion, lordship has passed an order on last day of July. Lordship will kindly come to that. It is on the last page.
So arguments concluded, judgment reserved.
No, my lord. They have taken the time. They have taken the time for 1 month. We have concluded.
That is not incorrect.
They have
Lord,
taken the
my
time
learned
till
friend-
October. Lordship, the trial judge said that kindly complete it within 2 days. You can. They said 2 days. But after that, they have taken the time.
And who's appearing for the respondent?
My lord, I beg to appear for the Muthuwalli, my lord, entire
we
August and
saying
September.
something knowing
they are
nothing?
there.
Which respondent has taken time before the civil court?
I
Lord,
think
we have not been able to
Muthuwalli.
start, my lord.
I
We
think
have not been able to start.
Muthuwalli, I think.
So that is incorrect, my lord. That is so unfortunate that this
Not
statement
only
is coming in the
incorrect,
High Court.
Mr. Rahim, you're appearing, senior advocate is appearing for fifth respondent.
Yes, my lord.
Waqf
Lord,
board. This is the
I am
Wait, sir. Whether your client is, the advocate has commenced arguments,
My lord, we are supposed to commence, my lord, on the 5th.
then you please complete it, sir.
My lord, they have argued for about 8 or 9 days, my lord.
Doesn't matter. You can finish in 2 days also.
I can finish. I will not
Ad
take more than 2
nauseam,
days.
they
my lord.
are
I
doing
will not
something.
take more than
You
2
should
days.
also argue for 8 days.
No, I will not take for more
They have
than
not
more than
started
2 days.
argument. Waqf board has not opened their mouth. It is only Muthuwalli doing it. Waqf board may take further time. This is what is
My lord,
happening. in the
my
court.
lord, I am making a statement, my lord,
He
that
was not
5th
there in the local court.
my lord, I am making a statement, my lord, that 5th is the first day and the last day I will argue the matter. It is going to be the first day and the last day. I will not argue beyond the 5th, my lord. My statement
You
can
have
be
heard the
recorded.
learned advocates for the parties, and in terms of the directions issued in the order dated 31st July 2023, the first civil judge within bracket junior division at Sialda has commenced hearing of the matter, and it is submitted that the hearing by the applicant, appellant was heard for a period of 8 days, and they have concluded the submission, and the next hearing date has been fixed on 5th October 2023, on which date the 5th respondent in this appeal has to make submissions. The learned senior advocate appearing for the 5th respondent has submitted before this court that on 5th October 2023, the 5th respondent in this appeal will conclude their submissions before the learned civil judge. The other parties who have to make their submissions are directed to conclude the same at the earliest, and the learned civil judge is entitled to fixed time frame within which the arguments have to be concluded. Full stop. Let the matter appear after vacation.
My lord, if it can come 1 day before the vacation, my lord, we'll try our best, my lord. If it can be sorted out, my lord, subject to your lordship's, my lord, board, my lord, of course.
On 18th October.
Great, your lord. My lord, except, my lord, only one indulgence, that senior advocate, my lord, I am still not advocate. That's not senior advocate.
The order sheet shows your senior advocate.
No, I believe there's
Calcutta High Court
Yes, ma'am.
probably has designated you as senior advocate. In fact, our applications we have opened up As of now, we have received 146 applications up to yesterday. In the
Well,
process.
only one indulgence. Lordship, vacation is coming, so 18th October,
No, we will see what happens on 18th. Suppose the learned civil judge is feeling threatened, we'll
and
say
then
that.
we have a chance of reply also. Well, that's
All right.
Your Lordship kindly extend the interim order.
Interim order is not limited.
Limited, it was. So till final order?
No, the interim order already granted, sir, take note, is extended till 1810.
Pardon?
Yes, sir. Passover matter.
Passover matter, item number 15.
This is my application.
But I'm sorry, my lord, I could not
No,
respond.
no problem. What should we do, sir, here?
But may I say, make this request to the court, my lord? Any day convenient to the court, my lord, kindly, my lord, fix this matter, kindly hear it out. But I'll tell you, Lordship,
But they say,
In the meantime,
in the meantime, what to be done?
my lord, there are two bodies as per, my lord, the memorandum. One is the Board of Governors, the other is, my lord, the Board of Trustees. The Board of Governors, my lord, by the impugned order, which was under challenge, had dissolved the Board of Trustees. But the Board of Governors is the superior body. Board of Governors is comprised of various state officials, the Pro-Vice Chancellor of the Calcutta University. There are various persons, about 18, 19 persons. Whereas the Board of Trustees are consisting of 4 members, initially 4 members, and now it has come down to only 1 member, which is Mr. Basu's client. Now, Mr. Basu's client, being allegedly the self-declared trustee, for the time being, without disputing his status, he being the sole trustee of the Board of Trustees, wants that the Board of Governors should not function. This is the sum and substance of his application. Now, kindly see the constitution of the Board of Governors and the constitution of the Board of Trustees.
Now, what did the learned single?
The learned single judge had set aside the resolution by which the Board of Governors had resolved, upon taking, of course, legal opinion. That's beside the point. That is not binding on the learned judge. Now, has come to this conclusion that the Board of Governors could not have dissolved the Board of Trustees. Now, please have a look to the constitution,
All right. Now,
Yes.
Till we hear the appeal and decide,
Yes.
let him be part of the decision-making process. That's it.
the constitution is such.
Because there is no interim order in this appeal as of now. If for granting an interim order, at least a preliminary hearing needs to be done. So instead of that, if you are going to, argue, if the arguments are going to be one and the same, it can be an argument in the appeal. In the meantime, let him be there.
But the only problem is,
I will keep accounts as per the board.
there are
30
three.
30 it is clear.
In the constitution or the memorandum, there is a treasurer of the institute. There is a treasurer of the Board of Trustees. Now, we do not know what is his status. He must first come out and disclose before the court as to what is his status.
That has been taken care of by the single judge.
That did not fall for consideration. Please have a look to at page 89. But kindly have a look to my stay application, page 89. I'm sorry, page 92.
What you can do one thing, you maintain status quo in terms of the orders passed by the learned. Or you maintain status quo.
On the basis of the single judge order.
What?
You maintain status quo
In respect of the order, single judge order.
30th May 2017.
My lord.
That will be the effect. But can this impasse be not resolved?
It
will affect the functioning of such a wonderful.
Yes, definitely. Yes. But the problem is, kindly have a look to 2 pages. First is page 92 of my stay application.
Memorandum
Yes.
page
No.
number, internal page number.
Internal page is 16.
16.
At the left hand side, these are the constitution of the Board of Governors. But page 92.
Clause 1.
Of the stay petition, GM1.
Also in my
Yes, those
application.
folded pages. Yes, those folded pages.
GA1.
My lord,
Actually,
takes
yes.
Q1.
But the folded pages one, my lord.
Yes.
Now, my lord, please take my lord, page 92, my lord, at the bottom, page 16.
16.
Now, my lord, left-hand side, my lord, at the top, my lord, the members of the Board of Governors shall hold office till a new Board of Governors is constituted. Your lordship finds, my lord, the president is PC Sen, Vice Chancellor, University of Calcutta. The treasurer, now the Pro-Vice Chancellor of the Finance University of Calcutta. 3 members representing the founder members, Director of All India Institute of Hygiene, Secretary Government of West Bengal Department of Education, representative of the central government, so and so, so and so. It goes on till Milord 24.
Yes.
Now, please take 23. This is very important. Treasurer of the institute. Now, Milord, kindly take Milord the Board of Trustees, Milord, at page 95.
Internal page.
Internal page 22.
Clause 32.
Yes. The
Milord-
trustees of the so and so.
Yes, the trustees, number 1 is there shall be a board of trustees whose number shall not be less than 3 and not more than 5. Now, who are the initial members? Mr. Dipen Shannal, Milord, he has expired in his place. The petitioner is there. This is self-styled, but Milord, he has not been appointed. I'll show the process of appointment. Number 2 is Sri Aurobindo Ray, Milord, he has died, nobody in his place. Then Sri Iris Chandra Ghosh, he died, nobody in his place. And Milord, Honorable Justice Yusuf Milord, a retired judge of our court, he has also passed away, Milord, he has not been replaced. Now, kindly take, Milord, the next page as to how, or the right-hand side page of that page, page 95, right-hand side, Rule 40. Whenever a trustee or any person appointed a trustee resigns or retires with the consent of his co-trustees, or any trustee either original or substituted dies or is absent for a continuous period of 6 months from India or leaves India for the purpose of residing abroad, or is declared insolvent or desires to be discharged from the trustee, or refuses or becomes in the opinion of the court trustees unfit personally and incapable to act in the trust, or accepts an inconsistent trust, a new trustee may be appointed by a trustee who has resigned, not done, none of the 4 has done, or by the legal representative of the trustee, original or substituted, who has died. But according to us, Milord, he has not been substituted, but I take for argument's sake, he has been substituted. For the sake of argument, I take that B has been complied with. Then C is trustee who is for a continuous period of 6 months absent from India, not applicable, or in any other case by the continuing trustees. Now then take Milord 2. If no appointment of a new trustee is made by any of the persons mentioned in clauses 1, A, B, and C above, then the continuing trustee may appoint a new trustee. Now, Milord, A, B, and C, Milord, neither has been complied with. Therefore, Milord, out of the 4, Milord, the original trustees, Milord, 2, 3, and 4, Milord, has not appointed anybody. So far as 1 is concerned, we dispute that he has been correctly appointed or legally appointed, but keeping that dispute for the present, Milord, aside, therefore, Milord, there is 1 trustee. But, Milord, clause 32 says there has to be minimum 3 trustees. So, Milord, as of today, Milord, there.
So according to you, the trust has become defunct.
Yes, that is why, Milord, it was dissolved.
That is not the case made out in the paper.
That's a different thing.
But we have answered to that.
Yes. But clause 32, Milord, in order to, Milord, have 2 bodies. Otherwise, Milord, we are not arguing the appeal.
No, this person is of a lot of nuisance values.
Milord, I won't comment on that, Milord, but
Has been recognized, page 24 of the state.
That is not the case made.
but any case, Milord, even if he is recognized, Milord, I don't bring that dispute at this stage.
Now,
But
let us see the impugned resolution.
yes, now, Milord, Milord, please take the page number 30. Yes, it starts from 36. The relevant at page 38. Milord, I'll be very candid, Milord, on this ground, Milord, it was not dissolved. I will not waste the court's time. That's yes.
Trustees remain.
No, this resolution is wrong, wrongly worded rather. What they could have said that based on legal experts' opinion, the trust board should consist of not less than 3. And in the absence of any nomination in terms of rule
Right.
so and so, a single member said to be nominated by a representative of the deceased trustee number 1 cannot form a valid board of trustees.
Right.
BOT.
Should have been. There's no doubt on that. But Milord, today, Milord, the writ petitioner to claim any representation over here has to, Milord, satisfy clause number 32.
But then for him to be removed or asking him to exit, we have to somebody has to take a decision that the board of trustees is a board of trustees. That body cannot be dissolved, but the body can be said to be defunct.
Right, sir.
On account of lack of quorum or lack of nomination in terms of A, B, C, D. So the academic council, I'm sorry, the board of governors have got no jurisdiction to dissolve the board of trustees. It can say the board of trustees will be there, but it cannot function
For the time being, because of the note.
Yes.
because of this impasse.
Right.
Because it should have minimum 3.
Absolutely, Milord, I don't join any issue on this. Milord, that is what has fallen from this court, Milord, is absolutely right. But Milord,
But what is the nature of interference this person does?
Milord, yes, the interference is he has to, Milord, Milord, object to everything.
No. What
This
they
is-
say,
Lord, I will request you Lord, to save this institution, not me. Save this institution. From the hands of the Lord, kindly see who are the respondents there.
Page 95, clause
This is
38.
August institution created by Dr. BC.
Milord, it is running from Dr. BC Rai, Milord, our ex-chief minister of this state. Milord, functioning
Now
Milord,
want to grab
properly.
the entirety.
Now, it is not a one person. It is a body, Milord, as I've shown, Milord, a governing body with, Milord, the vice chancellors of the Calcutta University. I'm sorry, pro-vice chancellors of the Calcutta University, but other state representatives, Milord. As against them, Milord, it is only one person who feels that the entire punch is wrong or incorrect. I don't use the, Milord, other strong language.
Well, I will request you Lordship to see once the clause 38 of
Yes.
the memorandum. Kindly come. Internal page 23 of that
but
folded.
the board of governors is heavily loaded by government nominees.
Yes.
All.
Yes.
Because serial number 10, 11,
Yes.
12, 13, 14, Chamber of Commerce, nobody will be an independent
No.
thinker. Because they are under the mercy of the government in respect of various notifications.
That's why the balance was
So
created.
you can, most of them won't even attend. Item serial number 10 to 16, you can never ever have. Then 17 and 18, once again government. So it is a completely loaded, sir.
Yes.
It with the central government also, Milord, serial number 9.
Ah,
So 38 and 46,
No,
please.
no.
he won't come, sir. He will see you take the attendance, leave of absence. AICT representative also probably.
Seldom comes.
Has never come perhaps.
Then there is no independent person.
No. That's the reasoning of the Honorable Single Judge.
10 to 16
Yes.
are all members of the industry who will not voice their opinion independently. All right. Since we have heard the learned senior advocate for the
But once
appellant
before that, your Lordship, present to 38, if your Lordship
since
kindly
the
wants.
appeal has to be heard.
Oh, okay.
Come on, at this juncture, the question of granting any interim order doesn't arise. And whatever was the situation which was prevailing prior to the impugned resolution of the Board of Governors dated May 30th, 2017 shall be maintained till the appeal is heard and disposed of or any orders are passed, whichever is early.
But may I make one unusual prayer? Bank is not a party. If you Lordship kindly add, all concerns are to act on the minutes of your Lordship's order.
No.
Again, I have
not
to
make
again
them,
come for the bank is not working on the basis of your Lordship's order.
Milord, may I say this, Milord?
Control is fully by the.
Clients are interfering in the banking process.
If you Lordship kindly add,
All
concerns, including banks.
parties are to abide by the above order.
But may I only make this request, Milord, as your
To
Lordship.
resolve this, sir.
Your Lord, yes, that's that.
Best is you exercise the power. Or we can appoint a special officer.
Will your lordships may kindly hear out the matter, my lord, on the day convenient to the court, so that will.
This is a government loaded body. There's nothing independent.
Yes, but my lord, this is one person, my lord, who is, my lord, standing in the way of all welfare
Basu
activities.
says that the main person is behind bars.
Yes.
No, no,
yes,
no,
yes,
I
yes,
don't.
yes, yes.
The person who stage
And my
managed
lord,
this.
see, our ground for delay is that he is such an influential person, we cannot move the repeat, sir.
No, 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 I don't
It's the
say.
ground I've taken. I'm
Education minister.
Choop na. I've taken this point in my petition. Younger to me, that's why he's enthusiastic more. This is our ground.
Educational institution, political
And
interference.
everywhere, my lord, this grabbing of power, nothing else. Education, let it go. But power should be there.
And how do your client claims he's appointed by the
Yes,
nominated?
he is the representative of the earlier.
So let him show the appointment letter.
Case 24, he has accepted it.
No, no, but whether
And this is
under a wrong advice, if somebody does anything, that will not validate his appointment.
Even now, it's not too late, sir.
Yes.
This resolution can be withdrawn. Saying that you cannot, Board of Governors cannot dissolve the Board of Trustees. Secondly, there is no necessity for a deed of trust. It has already been constituted. So only thing is, you can take a resolution that
in terms of that.
in terms of the bylaws or regulations.
Your lordships may kindly, very well. Kindly make an observation so that tomorrow the fingers are not pointed at me. Kindly make an observation to that effect so that we can think on those lines. Because otherwise, it may be said that during the pendency of the appeal, we
I
are
can
taking.
demonstrate, my lord, this
Their application.
governor has taken the resolution.
In 1981.
During the, after hearing the learned senior advocate for the appellant and the learned advocates for the respondent for a considerable length of time, we are of the prime facie view that the resolution adopted by the Board of Trustees, page number, sir?
But it's 38, the relevant part at 38.
No, that resolution of the Board of
38, but of GA1.
In our G.
No, in our GA.
Stay.
Prime facie we are of the
Page
view
38.
that the
Last
decision
but one.
taken by the Board of Governors holding that the Board of Trustees does not have a legally justifiable place is incorrect. On a prime facie reading of the Memorandum of Association and Rules and Regulations of the Indian Institute of Social Welfare and Business Management, we find that the Board of Governors have got no jurisdiction to dissolve the Board of Trustees. It may be a different case if, according to the appellant, the Board of Trustees is not constituted in accordance with
Clause 32.
Clause 32 of
Memorandum of Association and Rules and Regulations. But I'm sorry, of the Rules and Regulations. Rules and Regulations. But page 95.
of Rule 32 of the Rules and Regulations. The respondent petitioner claims to be a representative of one of the trustees,
Dipen Sanyal.
Dipen Sanyal, who's no more. This contention is being disputed by the appellant.
Now disputed, not in the court below. Court below there is no dispute.
Before this court. Be that as it may, come on. In terms of the rules and regulations, there shall be a Board of Trustees. And in terms of Rule 32, the number shall be not less than 3 and not more than 5. Therefore, we are of the prime facie view that the Board of Governors could not have taken a decision to state that the Board of Trustees has to be scrapped or has to be
Dissolved.
dissolved, which in our prime facie view is a decision taken without jurisdiction. This prime facie observation is made by this court to enable the appellants to ponder over the issue and seek legal advice. More so because the Board of Governors have to function in the best interest of the institution and ensure that the institution does not denigrate in any manner.
Grateful.
This the appeal in December or some date. We'll stop with this.
This was put in the.
No, no.
No, sir, prima facie will be-
December month.
First matter.
Milord, second of Milord, the appellate side will be taken up.
No.
Where is it?
December.
Complaints to be done by 7 PM today. And the top person is writing personal.
My lord is keeping this matter on December. We'll
Who's been
my lord.
lodged?
We'll get my lord to address.
With all our wishes,
I
we know
don't think-
something is in the offing.
I don't think.
Lordship, may I have leave to file an appeal, my lord, without certificate?
Let the affidavit of service in GA to be kept with the record.
Everything kept on record.
Everything.
See, sir.